This program is a community education production brought to you by the Bar Association of Montgomery County and the Montgomery County, Maryland Bar Foundation. The program is designed to provide you with general information regarding your rights and obligations under the law. It is not intended as specific legal advice. You should discuss the facts and circumstances of any particular matter with your own attorney and obtain advice specific to your case. The participants are local attorneys who have volunteered their time to bring you this program. We hope you find it informative and beneficial.
Welcome to Law School for the Public. I'm David Watkin, an attorney in Montgomery County, Maryland. Today we explore the rapidly developing area of electronic documents and records in civil litigation. 25 years ago, the documentary evidence in a lawsuit was on paper. Nowadays, it is almost entirely email, word processing documents, text messages, spreadsheets, social media, and other electronically stored information, or ESI as it is known in litigation. The overwhelming prevalence of electronic rather than paper records and the ever-increasing amount of electronic information has created challenges for litigants who must preserve, collect, and produce relevant data as part of the pretrial discovery process, which allows a party in a lawsuit to obtain the other party's relevant information. Questions as to what information each party can obtain from another party, what effort the producing party must go through to preserve and produce the information, and who has to pay for this are among the questions that are debated daily by litigants and judges. To help us understand these issues, we are joined by two Maryland attorneys with significant experience in this area. First, we welcome Alex Vinson, a partner at Shulman, Rogers, Gandel, Porty & Ecker in Potomac, Maryland. Alex represents companies and individuals in business litigation, including disputes between owners, officers, and directors of privately held companies. He also concentrates part of his practice on helping individuals and companies protect their intellectual property rights and confidential business information. Alex counsels clients on electronic discovery and recently spoke to the Montgomery County Bar Association on the use of electronic evidence at trial. We are also joined by Diane Kilcoyne, who is the Director of Litigation Support at Lurch, Early and Brewer in Bethesda, Maryland. Diane's practice focuses on disputes about large commercial contracts, real estate development, employment discrimination, and white-collar crime. Many of her cases involve voluminous electronic discovery. Diane has also spoken on electronic documents and records in litigation. Diane, Alex, thank you for joining us.
Thank you for having us.
Thank you.
And Alex, let's begin with you. How big a role do electronic records and documents play in civil litigation today?
It's huge, David. It's a big role, and it's primarily because everyone communicates using electronic documents now. Things that people used to dictate or handwrite on paper, they are now doing through word processors. Financial calculations are done through spreadsheets, QuickBooks software, things like that. So, and the number of documents that are generated is exponentially greater than what you used to see in paper form. So they form, it's hugely important. And because they're so easily altered or changed, you get into situations where it's very delicate how you have to treat them, how you have to preserve and collect them, and the things that you can find out about people and what they are doing and their actions are all reflected in how the documents have been changed and how you can see that in those documents.
We're going to get into a lot more of that in detail, but just as a general matter, are electronic documents treated differently than paper documents were treated, before electronic became so prevalent?
Well, in some ways, no. They're treated the same way in evidence and in discovery at trial, and I know you're going to get into that with Diane as well. But the one aspect where they're different is because they're so easily changed and altered, if they're not handled right in the discovery process, then a lot more care has been taken to make sure that they're not changed and that the evidence is preserved in the state that it was before the dispute began.
Is paper still relevant in litigation? Is paper part of a trial, or is it really not so much anymore?
It is still relevant, and people sometimes forget about paper because despite the prevalence of electronic information, human beings still like to see things on paper. They print things out, and they do keep paper files. So you can't forget about that. And there are sometimes paper documents that still assume great importance in a case, even when they're accompanied by a lot of electronic things as well.
Diane, Alex mentioned discovery quite a bit, and I talked a little bit about it at the outset. But for those of our viewers who aren't familiar with that term, can you tell us just briefly what is discovery in the context of commercial litigation or civil litigation?
Sure, Dave. A lot of people aren't aware of this process, and if they've never been to court, never been a litigant before, they may not be aware of what discovery is, but it's basically the process by which both parties to a litigation have to show information to the other side related to that litigation. It's a process by which one party will ask for specific categories of information and documents, and you have to turn it over to them. And it can be very voluminous, depending on the size of the litigation, and it can cover everything that's even reasonably calculated to lead to admissible evidence to be used at trial. So it covers all the background information related to the subject matter of the dispute.
And what is, in the context of electronic documents and electronic records, how do they get captured in discovery, or what are there any limits on what you can get, or how does that all work?
Well, it's interesting. Just this past year, they've looked at changing that under the federal rules of civil procedure. They've been looking at.
And those are the rules that apply in federal court, as opposed to the Maryland courts.
However, the state courts typically follow the federal rules. They will adopt them within a year or so of the feds, generally speaking. They're looking at maybe trying to limit the scope somewhat to include this concept of proportionality, which means that if you have a smaller case, one where somebody's suing over, say, a $20,000 breach of contract, you don't want to spend $15,000 doing your discovery process. It doesn't make any sense to the value of the case. And the concept of proportionality has been involved in litigation prior to this, and it's also been codified in the rules, but it's sort of buried deeper in the rules, and this year they've been looking to bring it forward to put it right in the very first sentence of the rule governing the scope of discovery. So that hasn't actually taken place yet, but it's expected to take place in December of this year.
And so that may reduce some of the burdens and scope.
That's the hope.
But as it stands now, if you and I were involved in a lawsuit over, let's say, some kind of contract dispute, and I wanted to see all of your electronic records relating to the case, is there any limit to what I could ask for, or what types of records I can get?
Not necessarily to the types. You couldn't get anything that was privileged, for example, or work product that you've communicated with your attorney. But as to the scope, it has to be something that's either relevant to the cause of action or designed to lead to relevant admissible evidence.
But in terms of the types of information?
Well, there's email, obviously, and as we were talking about, spreadsheets, everything's done electronically these days. So documents, spreadsheets, text messages, emails, voicemail messages, which then are usually transcribed digitally these days. There are internet website, that can be information that can come in, social media pages. There can be any type of data that your company uses, including structured databases, payroll information, HR information, anything that you store that relates to your lawsuit can be discovered.
Okay, so I'm seeking discovery from, let's say, your client, and I'd say, I want all the documents that are relevant to your client's relationship with my client. And that would include email and spreadsheets and text messages and all the things we've talked about. And now what do you have to do?
Well, you have to know sort of where to look. You would want to know what your client, what it's called sort of a data map, where your client stores their data, and be able to determine whether they even have anything that responds to the requests. Then you find it, look through it, gather it appropriately. As Alex touched on briefly, you want to make sure that you preserve it in a forensically sound manner so that you don't change the data by copying it. People aren't generally aware of this fact, but if you open a document or an email, you automatically change the document because the document contains what's known as metadata. And
what's metadata?
Metadata is an associated data field that's electronically embedded in the code at the beginning of a document. For example, I'm not exactly the highest technical person on that, but that's the layman's description of it, and it will change when you open the document, for example. Even if you don't make any changes to the text of the document, you have changed it.
So if I send a request to you saying, I want all the email, and you won't need to collect the email, how do you collect the email without changing it, in essence?
Well, there are software especially designed to collect from a server And you would typically use a trained forensic collector to go in and administer this software package to the server without disturbing any of the metadata.
And there's a good example, just to add to what Diane said. If we were looking at a document that you created that was really relevant in litigation, but she wanted to open it to find out whether it really was relevant or to make sure that it was something that you had an obligation to turn over, if she opened it and then closed it again, it might say last saved by Diane instead of last saved by you. And the key data is it was last saved by you. We don't care and we don't want to know when it was last saved by Diane. We want to know when it was last saved or changed by you, who's one of the parties to the case.
So how do you avoid that? If it seems almost like a chicken and egg problem, if you're trying to find the documents that need to be turned over to the other side, how do you determine which documents they are without changing the documents, in essence, is what you're saying?
Well, Diane alluded to this. There are various software programs that you can use that will collect it in a way that allows you to look at it or to sift through the metadata without actually changing the metadata or opening the document. And that's generally what you have to do in a situation like that. One of the other challenges that you encounter is, well, you might say, give me all the documents that are relevant to my case. Well, how do I know that? I can't just go in and say, well, these emails are all relevant to the case, because it's very hard to do that unless people are extremely diligent in how they store their emails. You have to go through and search them. And oftentimes you have to use search terms and figure out, well, when these words occur in a certain sequence in the email, I know that it's going to be relevant. So the game is, how do you pick a structure that allows you to get what you need, but without burdening the other side with turning over things that have nothing to do with the case and are just going to burden them and harass them.
Well, and speaking of burden, there's obviously a cost involved if you're hiring a trained forensic specialist or some other outside person, in addition to the lawyer that you're now paying to help you produce the stuff to the other side so they can defend your case or try to beat you in the case.
Right.
And so who pays for that? You know, if I serve a discovery request to my adversary and say, you know, I want all this information, and does the other side then have to pay to pull it all together and produce it to me?
My experience is generally not. Each side has to bear its own costs in producing electronically relevant information to the other side in a case. There will be exceptions when the sheer scale of what the other party is asking for is so broad and it's imposing such a disproportionate burden on the other side that the court might order the requesting party to bear some of that cost. There are other exceptions when it might be the nature or scale of the request. It might be that they're asking for people to search beyond just their active computer systems, to go back to the backup tapes, the archives, things like that. And the court might say, well, okay, you can do that, but if you want to do it, you're going to have to pay for it, not the party from whom you're seeking the information.
And what happens, Alex, if, let's say it's a relatively small dispute, like a $20,000 dispute, but there are records that would bear, emails and maybe text messages that would bear on, you know, who's right and which way the facts should go. What happens if the cost of doing all this eclipses the cost of or the amount in controversy?
Well, that sometimes does happen. You have to keep a careful watch on it as an attorney, because then, you know, your client's going to be unhappy if the cost of all the discovery collection is eclipsing what the amount in controversy is. So you have to decide these things up front. And there are some relatively inexpensive ways of collecting and preserving data with certain programs without having to hire an expert that's going to charge you by the hour, for example. So it depends on the size of the case. Sometimes a case will demand an expert with that kind of caliber that you're going to pay separately. Other times you might be able to spend a couple of $100s to get a software program that will collect and allow you to review things, but without having to spend a gazillion dollars on consultants and that kind of thing.
So Diane, it sounds like a little bit of a tightrope. You got to be careful that you don't inadvertently change the information. So you may need an expert, but you also have to be mindful of the fact that it could be so expensive to use an expert that it costs more than just paying the other side what they're asking for.
Yeah, as an attorney, you have to balance that and try to craft your plan for the collection process to include just what you need to get. So you want to do a preservation plan, which is broader than you actually collect. Generally, you will preserve something and then say, well, I think I I'm going to save that and make sure that it's a copy has been made, but I think we're ultimately only going to need a smaller portion of that, and that's what you would actually end up looking at and probably producing from. But there are ways that you can sort of cull that down, and the technology is changing every day and getting better, and there's more competition in the field, so the prices are changing too.
Like anything else.
Like anything else.
And so once you collect it all together, how does one go about giving it to the other side? Do you give them a disc, or do you email it to them, or what do you do?
Yeah, typically it depends on the size. We have done it via disk or via a flash drive, or you can upload it to an FTP site and they can download it that way.
So it's in electronic form. So for example, if I were seeking emails from your client, you wouldn't just print all the emails out and give them to me?
Not anymore, not since about 2007.
Can't do that?
No, and I've been in cases where people try to get away with doing that because they don't want you to see the metadata. So they'll just take the emails and print them all out and give you the stack of paper. And that's not good enough. You need to see the electronic version of the email as it exists in its native state, because that can sometimes tell you things that you wouldn't otherwise know from just getting the printed out version.
So in some respects, the electronic documents are more informative than the paper documents that we all used to litigate over 20 years ago, because when you get a memo that's from someone's file cabinet, you don't know when it was written, you don't know who wrote it necessarily, or who typed it up, or whatever.
Right.
Nowadays, I guess from the metadata, you're telling us that you can get some of that information.
Right.
All right, well, Diane mentioned the word preservation, and that's the next topic we're going to talk about a little bit. Kind of stepping back from litigation. Some of this comes on in anticipation of litigation. And to help discuss it, we've come up with a hypothetical that involves a client of ours named Clint Hillard, who is the CEO of a company. He's concerned about privacy, and in part because he's thinking about running for public office down the road. So in the event that he does decide to do that and leave the company, he wants to be able to make sure that none of that information gets out, so he decides to get his own private server, and instead of using the company email, he just uses his own server for his email, and that way when he leaves, he can just erase it all, and nothing to worry about, no paper trail.
Right.
Any problems? So let's say Clint is your client, Alex. Any problems with that approach if he comes to you and says, this is my course of action as the CEO of this publicly traded company?
Yeah, that would give me some heartburn, Dave. Yeah, you know, what I would tell him is, don't put anything in an email that you're not comfortable being published in the newspaper or someone else seeing. In his capacity as the CEO of the company, he has to assume that these are not private or personal communications. They are communications in his capacity as an agent of the corporation. And there are a lot of people, the board of directors, the shareholders, who might have an interest in what he's saying and what he's doing. So he can't just assume that he's going to be able to take complete personal control over this and decide what he thinks other people need to know and what they don't, if it relates to his business. So and he shouldn't also be using you know, the company's email to, you know, communicate purely personal things either. And when you mix those things up too, that creates problems as well.
Now, does he announce